The Ilgar Mammadov group of cases reflects the crackdown on human rights defenders in Azerbaijan since 2014. They relate to criminal proceedings which were brought against an opposition politician and civil society activists and human rights defenders. At the European Human Rights Advocacy Centre, we act for two of the applicants, Rasul Jafarov and Intigam Aliyev. In essence, the European Court has found that these prosecutions amounted to an abuse of the criminal law. Not only was there no reasonable suspicion for arresting and detaining them, but also there was no proper judicial oversight. But even more fundamentally and exceptionally, the court went further to find that in prosecuting them, the aim of the Azerbaijani authorities was to silence and punish them, either for having criticized the government or for their activities in the field of human rights and social rights and electoral monitoring, and to stop any future such work. More than that, as a result, the court found an unprecedented series of violations of Article 18 of the Convention. Because of the authorities' ulterior motives, they were restricting the applicants' rights for purposes other than those prescribed by the Convention. Reviewing the state of affairs in the 2018 judgment in Intigam Aliyev's case, the court concluded that these were not isolated incidents, but reflected a troubling pattern of arbitrary arrest and detention, retaliatory prosecutions, and the misuse of criminal law in defiance of the rule of law. And it amounted to a systematic failing by the courts to provide any genuine judicial oversight. Why do we still need to act? Are these historic cases? There is still a very urgent need to ensure that these court judgments are complied with, not least because of the continued repression in Azerbaijan of dissenting voices. What we've seen more recently has been a systematic attack on human rights lawyers by having their licenses suspended and then they're being disbarred. Very recently, we've seen a large-scale arrests in Baku of people demonstrating following the clashes on the Azerbaijani-Armenian border. This led to a strong statement on 31st July from the PACE rapporteurs, decrying the use of administrative detention and public order charges based on fabricated evidence, and the torture of detainees. And they make an explicit link to the court's Article 18 judgments. There have now been 9 Article 18 judgments against Azerbaijan involving 13 people, taking into account the recent decisions relating to the investigative journalist Khadija Ismailova and the human rights defenders and activists Leyla and Arif Yunus, all of whom EHRAC also represents. And these cases have not yet been added to the Mammadov group. The pressure which has been exerted by the Committee of Ministers and other Council of Europe bodies has led directly to some very positive developments in these cases. Of course, the politician Ilgar Mammadov was eventually released, but more than that, both his criminal conviction and Rasul Jafarov's convictions were quashed by the Supreme Court in April this year. In EHRAC's 2 cases, Jafarov has also been compensated for his unlawful arrest and imprisonment, and he's had confirmation that there's no record of his conviction in the public registry. In September 2019, Intigam Aliyev was allowed to return to his office, which had been sealed for more than 5 years, and the documents and files which had been seized were returned to him. However, the convictions of Intigam Aliyev and the other applicants have still not been quashed, although there is no basis whatsoever for treating them differently to Mr. Mammadov and Mr. Jafarov. In the March 2020 interim resolution, the Committee of Ministers underlined explicitly that restitution in these cases requires the quashing of the applicants' convictions, their erasure from their criminal records, and the elimination of all other consequences of the criminal charges brought against them, including by fully restoring their civil and political rights. For Mr. Aliyev, as his criminal conviction still stands, he's not able to receive grants for his NGO Legal Education Society, and his bank accounts remain frozen, and he's not been compensated. He's also still subject to a ban on leaving the country. And indeed, in December 2019, a further travel ban was imposed on him for the alleged failure of his NGO to pay a tax debt from 2011 to 2014. For Ana Mammadov, his outstanding conviction means that he is barred from standing in elections, parliamentary and municipal. So to summarise, in terms of individual measures, the authorities should discontinue the persecution of members of civil society and end all restrictions on their rights, including the termination of the criminal case that was initiated by the General Prosecutor's Office in 2014 against Azerbaijani human rights organisations, which currently still remains open. The quashing of the applicants' criminal convictions and the lifting of all criminal and tax sanctions which were imposed on both NGOs and their leaders, as well as other restrictions stemming from the criminal prosecutions, such as the freezing of bank accounts and bans on leaving the country. It's also imperative that the activists and human rights defenders can resume their professional and political work. This means ensuring an enabling environment for human rights defenders and their organisations, in which they can effectively exercise their rights to freedom of association, including accessing funding. This links directly to the question of general measures. What is clear is that the restrictive NGO legislation is at the root of the repression. In the 2016 Rasul Jafarov judgment, the court found the new onerous regulations, coupled with the reportedly intransigent and arbitrary manner in which they were applied by the authorities, made it increasingly difficult for NGOs to operate. The Venice Commission has found the NGO legislation to be in breach of international standards. And in his third-party intervention in the Jafarov case, the former Commissioner for Human Rights said that by deliberately attempting to make independent human rights work in Azerbaijan impossible, this restrictive framework constitutes an integral pattern of the judicial harassment and reprisals against human rights defenders currently prevailing in Azerbaijan. Therefore, the authorities should amend the domestic laws regulating NGO activities so that they are brought into line with relevant international human rights standards, ensuring that the current NGO registration procedures and the procedures for registering NGO grants are abolished and substituted with simple notification procedures. The barriers to the operation of international donors in Azerbaijan are eliminated, and donor organisations are able to provide grants to Azerbaijani NGOs without prior approval by the authorities or any other hindrance. And heavy fines and other disproportionate sanctions in the Code of Administrative Offences for violations of domestic legislation relating to NGO operations are lifted. Thank you very much for your attention.